it's Advocate Sonalika, your legal advisor and consultant. Today I am going to explain a very important topic in criminal law, which is dispute regarding immovable property. This aspect deals with the property which are not movable, such as land, water, or the boundaries thereof. Now, the dispute as to immovable property under CRPC has been described under following sections, which are section 145, 146, 147 and 148. According to section 145, it deals with the procedure where dispute concerning land or water is likely to cause breach of peace. Now, the next section, which is section 146, it deals with the power to attach subject of dispute and to appoint a receiver. Now, section 147 deals with dispute concerning of use of land or water, and the last section, which is section 148, deals with the local inquiry to this aspect. Now, according to section 145 of this aspect, which deals with the procedure where dispute concerning land or water is likely to cause breach of peace. According to this section, whenever an executive magistrate is not satisfied from a report of a police officer upon the information that the dispute is likely to cause a breach of peace exists concerning any land or water or the boundaries thereof within his local jurisdiction, he shall make an order in writing stating that the ground of his being so satisfied and requiring the parties concerned in such dispute to attend his court in person or by pleader on a specified date and time, and to put in written statement of their respective claims as respect the fact of actual possession of the subject of dispute. Secondly, for the purpose of this section, the expression land and water include building, market, fishery, crops or other products of land, and the rent or profit of any such property. Thirdly, a copy of order shall be served in the manner provided by the code for the service of a summons upon such person or person as the magistrate may direct, and at least one copy shall be published by being affixed so some conspicuous place at or near the subject of dispute. Fourthly, the magistrate shall then, without reference to the merit or the claim of any of the parties to a right to possess the subject of dispute, pursue the statement so put in here, the parties receives all such evidence as may be produced by them. Take such further evidence, if any, as he thinks necessary, and if possible decides whether and which of the party was at the date of the order made by him, under if possible decide whether and which of the party was at the date of the order made by him under subsection 1 in possession of the subject of dispute. provided that if it appears to the magistrate that any party has been forcibly or wrongfully disposed within 2 months next before the date on which the report of a police officer or other information was received by the magistrate, or after that date and before the date of his order under subsection 1, he may treat the party so disposed as if the party had been in possession on the date of his order under subsection 1. Fifthly, nothing in this section shall preclude any party so required to attend or any other person interested from showing that no such dispute as aforesaid exists or has existed, and in such case the magistrate shall cancel his said order and all further proceeding thereon shall be stayed. Subject to such cancellation, the order of the magistrate under subsection 1 shall be final. Now, sixthly, if a magistrate decides that one of the party was or should under the proviso or subsection 4 be treated as being in such possession of the said subject, he shall issue an order declaring such party to be entitled to possession thereof until evicted therefrom in due course of law, and forbidding all disturbance of such possession until such eviction, and when he proceeds under the proviso to subsection 4 may restore to possession the party forcibly and wrongfully disposed. The order made under this subsection shall be served and published in the manner laid down in subsection 3. Seventhly, when any party to any such proceeding dies, and the magistrate may cause the legal representation of a deceased party to be made a party to the proceeding, and shall thereupon continue the inquiry. And if any question arises as to who the legal representatives of a deceased party for the purpose of such proceeding is all person claiming to be representatives of the deceased party shall be made parties thereto. Now, the next provision to this section says that if the magistrate is of opinion that any crop or other produce of the property, the subject of dispute in a proceeding under this section pending before him is subject to speedy and natural decay, he may make an order for the purpose, custody or sale of such property, and upon the completion of the inquiry shall make such order for the disposal of such property or the proceeds thereof as he thinks fit. Next, the magistrate may, if he thinks fit, at any stage of the proceeding under this section, on the application of either party, issue a summons to any witness directing him to attend or to produce any document or thing. Next provision to this section says that nothing in this section shall be deemed to be in derogation of the powers of the magistrate to produce under section 107. Next section of this aspect to disputes as to immovable property is section 146, which deals with the power to attach subject and to appoint receiver. According to section 146 of the CRPC Act, if the magistrate at any time after making the order under subsection 1 of the section 145 considers the case to be one of the emergency, or if he decides that none of the party was then in such position as is referred to in section 145, or if he is unable to satisfy himself as to which of them was then in such possession of the subject of dispute. He may attach the subject of dispute until a competent court has determined the right of the parties thereto with regard to the person entitled to the possession thereof, provided that the magistrate may withdraw the attachment at any time if he is satisfied that there is no longer any likelihood of breach of the peace with regard to the subject of dispute. Now, subsection 2 to section 146 says that when the magistrate attaches the subject of dispute, he may, if no receiver in relation to such subject of dispute has been appointed by any civil court, and make such arrangement as he considered proper for looking after the property, or if he thinks fit, appoint a receiver thereof, who shall have subject to the control of the magistrate all the powers of a receiver appointed under the Code of Civil Procedure 1908, provided that in the event of a receiver being subsequently appointed in relation to the subject of dispute by any civil court by the provided that in the event of a receiver being subsequently appointed in relation to the subject of a dispute by any civil court, the magistrate shall order a receiver appointed by him to hand over the possession of the subject of the dispute to the receiver appointed by the civil court, and shall thereafter discharge the receiver appointed by him. Now we come to section 147, which deals with the dispute concerning right of use of land or water. According to section 147, whenever an executive magistrate is satisfied from the report of a police officer and upon other information that a dispute is likely to cause a breach of the peace exists regarding any alleged right of user of any land or water within his local jurisdiction, whether such right be claimed as an easement or otherwise. he shall make an order in writing stating the ground of his being so satisfied, requiring the parties concerned in such dispute to attend his court in person or by pleader on a specified date and time, and to put in written statement of their respective claims. Now, subsection 2 to this section says that the magistrate shall then pursue the statement so put in her. Magistrate shall then pursue the statement so put in. Here the parties receive all such evidence as may be produced by them respectively, consider the effect of such evidence, take such further evidence if any as he thinks necessary, and if possible decide whether such right exists, and the provision of section 145 shall in so far as may be applied in the case of such injury. Subsection 3 to section 147 says that if it appears to such magistrate that such right exists, he may make an order prohibiting any interference with the exercise of such right, including in a proper case, and an order for the removal of any obstruction in the exercise of any such right, provided that no such order shall be made. The right is exercisable at all times of the year unless such right has been exercised within 3 months next before the receipt under subsection 1 of the report of a police officer or other information leading to the institution of the inquiry, or where the right is exercisable only at particular season or on particular occasion, unless the right has been exercised during the last of such season or on the last of such occasion before such receipt. Subsection 4 to section 147 says that when in any proceeding commenced under subsection 1 of the section 145, the magistrate finds that the dispute is as regards an alleged right to the user of land or water, he may, after recording his reason, continue with the proceeding as if they had been commenced under subsection 1, and when in any proceeding commenced under subsection 1, the magistrate find that the dispute should be dealt with under section 145, he may, after recording his reason, continue with the proceeding as if they had commenced under subsection 1 of the section 145. Now we come to our next section, which is section 148, which deals with the local inquiry with the dispute. And according to section 148 subsection 1, whenever a local inquiry is necessary for the purpose of section 145 and 146 or 147, a district magistrate of or a sub-divisional magistrate may depute any magistrate subordinate to him to make the inquiry and may furnish him with such written instruction as may seem necessary for his guidance, and may declare by whom the whole or any part of the necessary expense of the inquiry said shall be paid. Subsection 2 to this section says that the report of the person so disputed may be read as evidence in the case. Now, subsection 3 to this section says that when any cost have been incurred by any party to a proceeding under section 145, section 146 or section 147, the magistrate passing a decision may direct by whom such cost shall be paid, whether by such party or by any other party to the proceeding, and whether in whole or in part or proportion, and such cost may include any expenses incurred in respect of witness and of pleader fees, which the court may consider reasonable.